Hello, my name is Peter Noorlander. I'm a human rights lawyer. I'll be talking about defamation from the point of view of international human rights law and the tension that exists between international human rights law standards and the laws and practices of countries across the world. Defamation is the most often used legal tool to silence journalists and bloggers. Defamation is a very noble and a very worthy purpose, which is to protect the reputations of individuals. International human rights law protects the right to a reputation, for example, under Article 17 of the International Covenant on Civil and Political Rights. And that means that states are under a duty to implement that and to protect reputation. The purpose really is to protect people against untrue allegations that undermine them in the eyes of society. So, for example, if allegations are made of corruption, of theft, of human rights violations, those are serious issues which, if they are untrue, do serious damage to the people against whom those allegations are made. However, while the aim of these laws is certainly legitimate, they are easily abused by public officials and politicians who want to hide acts of corruption or other acts of wrongdoing. It's extremely easy for a politician or for a public official to claim that when a story is published about them, that they're corrupt, for example, to claim that those allegations are untrue, and to insist that the journalist or the blogger who made those allegations proves that those claims are 100% true to a very high standard of proof. It's extremely easy to bring such a case because a politician that wishes to bring a case like that has the only thing that they need to do is to A, hire a lawyer, and B, then go to a court and say the story that this journalist has published is untrue. That's all that they need to do, and that it harms their reputation. A judge or a court would usually assume that that indeed harms reputation. The burden then shifts to a journalist to turn up with a lawyer or with a team of lawyers and to bring exhaustive proof of the fact that, that the allegations that they made are true. If they can't do that, they face, in some countries, prison, they face fines, they face paying heavy damages, and regardless of that, they have to invest in building a legal team. So they have to spend sometimes significant sums of money to hire lawyers and to defend themselves. The financial burden of that alone is a significant hindrance to their journalism, and is one of the facts that in some countries journalists won't even publish stories which they know to be true, but for which they fear that they're going to be sued. And they know that they're not going to be able to hire the lawyers that they then need to defend themselves. As I said, defamation laws over the years have become the most widely used tool by public officials and by politicians to silence journalists who write about them. The reason for that is, as I just said, it's extremely easy to bring these cases, and it's very hard for journalists to defend themselves. So it's a very simple tool, and it's very effective. That means that in countries around the world, you've seen a significant body of law develop around issues of defamation law, and at the level of international human rights courts, the European Court of Human Rights, the Inter-American Court of Human Rights, the UN Human Rights Committee, the African Court of Human and People's Rights, a body of law has built up that sets out the standards that ought to be applied from the point of view of human rights law in terms of the conflicts between the right to freedom of expression on the one hand and the right to a reputation on the other hand. And it's those standards that I'm going to elaborate on in the next couple of minutes. Let me give you a couple of examples of the kinds of cases that we come across in this field of law. I'll just focus on two, one from Singapore and one from Russia, to illustrate the very real dangers that exist for journalists and for bloggers. So the Singapore case is about a blogger. His name is Roy Ying, and he is a young man who published a blog called The Hard Truths about issues of the management of public funds in Singapore. And one of the main issues that he was writing about was about how the Singaporean public pension fund is being managed. He came across information that led him to believe that some of the funding here was being mismanaged. And he pointed out exactly how that was being mismanaged. And he explained to Singaporeans what that meant in terms of their own pensions, the amount of money that was available for their pensions. Like everything else in Singapore, the pension fund is managed by the ruling family. And the minute that in Singapore you criticize the ruling family, you are in trouble and in real danger of getting sued for defamation. The fact that he made these allegations, the Singaporean Prime Minister felt that that harmed his own honor because it implied that he personally was not managing the pension funds well, and so he brought a case for defamation. And the pattern was very simple. He got lawyers, he went to court, and he said, these allegations about me are untrue. They harm my reputation. I demand that the court declares that these allegations are untrue, and I demand damages. A libel lawsuit then ensued, whereby the Prime Minister of Singapore hired an expensive legal team and demanded serious hundreds of thousands, millions of Singapore dollars in damages. The blogger, whose day job was as a hospital porter, was unable to get lawyers. He launched a crowdfunding appeal through which he funded some money through which he could hire a lawyer, and he fought the case as best as he could. Unfortunately, under Singaporean law, the level of proof demanded for him to win the case was so high that he was unable to satisfy that, and he lost the case. You might have thought that, seen as the claimant against him is the Prime Minister who has access to state media to put his side of the story, that a simple finding that the allegations were untrue would be sufficient to remedy the harm done to his reputation. Unfortunately, that's not how the Singaporean defamation laws work. The Singaporean courts awarded a very high level of damages against the blogger, which means that he will spend the rest of his life paying off in installments this finding of defamation. He also lost his job as a hospital porter because in Singapore, all jobs in the public sector, which is where he works, are indirectly or directly controlled by the government. And because he had wronged the Prime Minister, he was unemployable and therefore lost his job. There is no appeal to an international human rights court because Singapore is not a party to any of the international human rights treaties, and therefore this is where the story ends for Roy Ying. Unfortunately, he will be paying off these libel damages for the rest of his life. He will no longer be blogging. He will no longer be writing about any issues that are of public controversy, and the Prime Minister has effectively silenced him. This is but one example of how defamation laws are very easily abused to silence people who criticize people in public life. Another example is in Russia, where a blogger in a town in Siberia called Sergey Resnick criticized local public prosecutors. He basically said that they weren't good at doing their job, and he also criticized their appearance. He likened one of them in particular to a tractor driver, which was a particular insult apparently in Russia. He then got sued under Russian criminal laws on defamation, which do not allow for any kind of defense of public interest, which resulted in him being imprisoned for 3 years. He's currently serving that prison sentence. He has appealed to the European Court of Human Rights, which in due course will hopefully give a judgment that will recognize his right to freedom of expression, and which will hopefully compel the Russian authorities to release him. However, in the interim, he is still in prison, and that's one other example of the way that criminal defamation laws are being used. They can end in the imprisonment of the journalist or of the blogger concerned. And that threat in itself of imprisonment is a very powerful threat which will keep many journalists from writing about issues that are of public interest. So those are just two examples, one of them being civil, but one of them being criminal. And that's important to note straight away. It's that defamation laws come in both civil and in criminal form. Historically, the criminal laws are prevalent. They are the oldest, and in 80% of countries around the world have criminal laws that make it a criminal offence to make allegations about somebody that are defamatory. This is a serious matter because under criminal law, you potentially face prison, you face heavy penalties such as fines, and you also face the use against you of the police and the sort of the prosecutorial machinery that exists in many states. This means that journalists can get picked up in the middle of the night by police, or usually at dawn raids. This means that media houses, media offices can get raided by police when there have been accusations of defamation, because those are criminal offences and those are then criminal law type responses that are brought to bear against them. Criminal defamation cases also often require journalists to defend themselves against a criminal standard of proof, which is a very high standard, and traditionally do not allow for journalists to argue that the allegations that they made were in the public interest. In some countries, there is a public interest offence that can be used only if the allegations made are purely of public interest. In other countries, there is absolutely no public interest offence whatsoever, and journalists simply have to bring the full proof of their allegations. This is particularly problematic when journalists rely on sources that are anonymous, or when journalists rely on materials that have been leaked to them and that are confidential. Because of the threat of imprisonment, the kind of chilling effect that comes with criminal defamation laws is particularly strong. No journalist wants to be imprisoned for their work. It's as simple as that. Civil defamation laws are also not unproblematic. In many countries, they can result in the award of very high judgments in terms of monetary damages. Awards of hundreds of thousands and sometimes millions of dollars are not uncommon. And this also exerts a serious chilling effect for journalists and for media houses who often lack the financial resources to pay those kinds of damage awards. Civil defamation cases also often have a habit of dragging on for a very long time, meaning that journalists can be engaged in legal battles that last months and sometimes years to come to a conclusion. And that, along with the need for journalists to hire legal teams, means that there is a constant drain on their resources, both financially and in terms of their own time. And that instead of being able to focus on their own journalism and on their own ongoing reporting, they are being forced to divert their own resources, financial and in terms of their brainpower, to defending legal claims against them. International human rights law requires that journalists who face defamation claims, whether they're civil or criminal, have a number of defenses available to them. Any journalist should be able to bring a defense of truth. Any journalist should be able to bring a defense of their allegations being on a matter of public interest. Any journalist or blogger being sued for defamation should be able to bring a defense that what they said was a matter of opinion and that their statements were fair comments on issues of public interest. Should a court nevertheless find that a particular statement was defamatory, international human rights law also requires that a judgment that is awarded is proportionate, and that any financial award, whether it's a fine or an award that damages be paid to the person that has been defamed, is proportionate and within the financial means of the journalist or of the media outlet involved. That is quite significant because it means that a journalist or a media outlet should not face bankruptcy as a result of one individual case. International human rights law has also very clearly held that imprisonment for defamation is always a violation of the right of freedom of expression. No journalist, in other words, should face imprisonment for defamation. Now, these are standards that have been developed by the international human rights courts, the European Court of Human Rights, the African Court of Human and People's Rights, and the Inter-American Court of Human Rights. Unfortunately, there's a clear tension between the standards developed by these international courts and by the laws and practices in many countries around the world. Damage awards are often still too high and often do, in fact, result in bankruptcy of media outlets. Those cases then need to be appealed to international human rights courts and are often won, but by the time that a judgment comes from an international human rights court, it can be too late and the media outlet can be out of business. Similarly, imprisonment should never occur under the standards developed by international human rights courts. Unfortunately, some national countries still do imprison the journalists for defamation, and those cases, such as the case of the Russian journalist, which I mentioned, then need to be appealed to the European Court or to other international human rights courts. So there is a clear tension between international standards and the laws and practices at the national level. There is, however, a very clear and discernible trend towards compliance with international human rights law standards. If we compare the situation on the ground 10 or 15 years ago to what is going on now, we see that a lot fewer journalists are still imprisoned for defamation. For example, in the Americas, there isn't a single journalist imprisoned for defamation at the moment, and that's a clear victory for international human rights law. Similarly, we can see a very clear trend towards the decriminalization of defamation laws. As I said, imprisonment in itself has been held by international human rights courts to violate the right to freedom of expression, and that pulls the rug from underneath quite a number of criminal defamation laws. There have been recommendations made by the special rapporteurs at the level of the United Nations and at the level of the African and Inter-American human rights mechanisms, who have strongly recommended that states should decriminalize their defamation laws, and states are beginning to respond to that. We have seen the legislatures in countries such as Ghana and Armenia moving to decriminalize their defamation laws. We are currently seeing the South African parliaments introducing laws, a single law to decriminalize libel, and we are seeing international human rights courts still coming out with very clear judgments recommending that states should decriminalize their laws. So if there's a positive to be taken away from this, it is that despite the fact that laws on defamation still are the most easily abused legal tools, there is a movement, albeit slow, but still a movement towards compliance with international human rights law standards in this area. And it is my very firm prediction that if we look another 10 years ahead, we will see criminal defamation laws no longer existing in a number of countries, and we will see clear defenses required by international human rights law being available to journalists in countries where they aren't now. This development towards greater compliance is slow and it's incremental, but it's very clear and it's discernible, and it's also irreversible. States are not going back towards the practices of 10, 20 years ago. They are moving towards the practices that are required by international human rights law. That is great credit to the lawyers and the activists that are working very hard on the campaigns to decriminalize libel, for example. And it really means that we will see a situation in 5, 10, 20 years where journalists will no longer fear defamation laws to be used to silence them.